Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Cases that should have gone to the Supreme Court of Canada, but didn't. Eric Redmond applied for a permit to allow a hydroelectric dam to be built in the area of the Acumen First Nation. The Ministry of Forests in British Columbia denied the permit on the basis of the fact that the area was protected by First Nations. Specifically, the Ministry of Forests said that the area held specific cultural significance and religious importance to the First Nations community in that area. There were no specific environmental concerns that were raised in denying the permit on the basis of the fact that there were these religious issues, but merely that it was a culturally significant area. Mr. Redmond appealed, arguing that the right to freedom of religion did not protect individuals who were Indigenous from having control over whether permits were granted or having participation in consultation over whether permits were granted on areas of religious significance to their communities. And this case raises very important issues. The duty to consult Indigenous communities is absolutely important, and the duty to respect Indigenous cultures and histories is also significantly important. But at the same time, does this duty engage the Charter of Rights and Freedoms? Does it engage the right to religious freedoms, or is this more grounded in really the Indigenous people's ability to control their traditional territory and the rights that are enshrined in Section 35 of the Constitution? This case raises fascinating issues that the Supreme Court of Canada could have gotten into about the interplay between Section 2 rights under the Charter as well as rights under the Constitution that belong to Indigenous people in relation to their land, and how ministers of forests and environment have to consider those intertwining relationships if there is even an intertwined relationship. The role that the Charter plays in assessing the importance of granting or not granting a permit for a dam or any type of work on Indigenous land is significant because it has application across the country, not just in British Columbia where there are not necessarily treaties, but in any area where an Indigenous community may claim a religious right in a period of or a location that's not covered by treaty agreements. This is an important case that could have been considered by the Supreme Court of Canada to broaden the way that Indigenous communities can protect and assert protection over various tracts of land and over various places, and better support Indigenous rights in Canada. And unfortunately, the Supreme Court of Canada missed the opportunity to really see the significance of this case in advancing the need for Indigenous communities to have autonomy and control over their lands, both traditional, treaty, and otherwise. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.